119. Treason as a breach of faith. In 1769, Sir William Blackstone defined treason in his Commentaries on the Laws of England, Book 4, Chapter 6, in these terms. Treason, proditio, in its very name, which is borrowed from the French, imports a betraying, treachery, or breach of faith. It therefore only happens between allies, for treason is indeed a general appellation made use of by the law to denote not only offences against the king and government, but also that accumulation of guilt which arises whenever a superior reposes a confidence in a subject or inferior, between whom and himself there subsists a natural, a civil, or even a spiritual relation, and the inferior so abuses that confidence, so forgets the obligation of duty, subjection, and allegiance, as to destroy the life of any such lord or superior. Treason is thus a breach of faith between allies or between those having duties or obligations one to another. The echo of the doctrine of original sin, man's violation of his covenant with God, is clearly in the background here. It is understandable, too, why the Middle Ages and Europe up to as late as 1828 regarded as petit treason the murder of a husband by a wife, or a master by a servant, or of a bishop by his priest. In England, the Treason Act of 1351 spelled out the various aspects of treason, and 5 classifications are still valid in English law today. These are, first, composing or imagining the death of the king, queen, or of their eldest son and heir. Second, violating the king's consort, the wife of his eldest son and heir, or his eldest unmarried daughter. Queen Anne Boleyn was convicted of treason on this ground as a supposed party to her alleged violation. Third, levying war against the king in his realm. Fourth, adhering to the king's enemies, in terms of which Sir Roger Casement in 1916 and William Joyce in 1946 were convicted and executed. Joyce was legally an American citizen, but, having received the king's protection and peace as a resident of England for some years, he was therefore guilty of a breach of faith. Fifth, slaying the Chancellor, Treasurer, or the king's justices while in their places doing their office. The law, however, was silent about offences on one side of the two parties, the king's side. Sir Matthew Hale, in the History of the Pleas of the Crown in the 17th century, wrote, "Because, as the subject hath his protection from the king and his laws, so on the other side the subject is bound by his allegiance to be true and faithful to the king." Although there was no legal precedent for it, Charles I was tried and condemned in effect as a traitor for waging war against the laws and people of England rather than protecting them. It was precisely a breach of faith that Charles was rightly charged with. This breach of faith was not mere human fallibility, but deliberate and radical. After the Restoration, which Hale worked for, the regicides were charged with treason on the ground that the king was supreme governor, subject to none but God, and could do no wrong, and that if he could do no wrong, he could not be punished for any wrong. It is interesting to note that while the trial of Charles I has many critics, the trial of the regicides has few. The trial of Charles I undercut statist absolutism, while the trial of the regicides upheld that same absolutism. Breach of faith, thus, has largely been defined in one direction. Neither Charles I, nor Hitler, nor Stalin, for that matter, are condemned for breach of faith, but on other grounds, the latter too, in varying degrees, for crimes against humanity, The regicides and the German officers, however, were executed as traitors. In the Western world and elsewhere, treason is thus seen as a one-way street. A strong current from the Old Testament prophets through medieval and Reformation writers has seen it as a two-way street, although some have differed on the punishment of the ruler, whether by God, by magistrates, or by any man. The theological roots of this lie in the Bible and the doctrine of the covenant. God's covenant of grace with man was indeed pure grace, yet out of pure grace, God bound himself to fulfill certain promises to covenant man. Moreover, in a restatement of the covenant to Abraham, God binds himself by an oath to himself to be faithful to the covenant. Genesis chapter 22, verses 16 to 18. Not only so, but in pure grace, God undertakes to provide the victim for man's treason as well as a perfect covenant keeper. In the person of Jesus Christ, God incarnate. By this means, God underscores the mutuality of the covenant and the necessity of faithfulness on both sides. Attempts have been made to introduce mutuality into the new religion. Humanity has a duty, we are told, to its unfortunate members, to the savages, those discriminated against, whether minority groups or sexual deviates, towards criminals and so on. Statist action is commonplace towards providing this help. However, it is not mutuality, in that no responsibility is laid upon these groups. The homosexuals and the abortionists are not asked to meet a standard other than their own. Thus, the mutuality of the religion of humanity is not mutuality at all. It is the subsidy of some by others, and the surrender of one faith and law to another. Is there a breach of faith where there is no common faith or alliance? And is there treason where no protection and peace are provided? When and where a state has explicitly or implicitly declared war on a segment of society, is it treason to resist? Or is it self-defense and survival? Thus, in 1946, the Attorney General of England, Sir Hartley Shawcross, MP, declared, "Parliament is sovereign. It may make any laws. It could ordain that all blue-eyed babies be destroyed at birth." It should be remembered that Shawcross was chief British prosecutor at the Nuremberg War Trials. He held that those trials were free of politics and laid down great and valid legal principles. Lord Shawcross, who was knighted in 1945 and made a life peer in 1959, was a prosecutor as a matter of duty of Dr. Alan Nunn May, a scientist found guilty of treason, and Rebecca West tells us that Shawcross showed that he was heavy-hearted under the necessity of making the prosecuting speech, and he waited for the sentence with an apprehension rarely shown even by a defending counsel. Shawcross was also the prosecutor in the Dr. Klaus Emil Fuchs atom spy case. A Labour Party member and an internationalist in his humanism, Shawcross still demonstrated in these latter two cases that, whatever his sympathies, the state has neither friends nor constraints. All blue-eyed babies or anyone the state prescribes, Nazis, communists, and all others, are subject to the will of the state and its disposal. In practice, thus, the particular state is the sovereign, and it speaks as sovereign man, and as the reigning God. It speaks in terms of its own interests, and particular men are expendable. The state, however, sees itself increasingly as the voice of humanity. Thus, the US feels a world responsibility to all men, and a moral obligation to interfere in Vietnam and Rhodesia, but no obligation to unborn babies. In the name of humanity, the modern state can prescribe any group within humanity because it recognizes no law beyond this world and no God other than itself. A Jacobin edict issued in the French Revolution in the name of man declared, "All is permitted those who act in the revolutionary direction." In terms of the newer humanism, the humanitarian state is that revolutionary agency. As a result, the definition of treason is blurred. All sin against God is treason to God, but in terms of human society, God has varying degrees of offences and corresponding requirements for restitution. The principle is summarised in the case law with respect to abortion, which concludes, "And if any mischief follow, then thou shalt give life for life, eye for eye, tooth for tooth, hand for hand, foot for foot, burning for burning, wound for wound, stripe for stripe." Exodus chapter 21, verses 23 to 25. Restitution in proportion to the offence is mandatory. If, however, treason is against humanity, then at every point we are guilty if we offend an unwritten and a changing quote-unquote law. In my travels onto college and university communities, I often find startling examples of this crime. For example, all ethnic jokes are a crime against humanity. Is this ludicrous and extreme as an example? I would have thought to prior to 1976, when an extensive outcry forced the resignation of Secretary of Agriculture Boots from President Ford's cabinet because he told a totally tasteless and vulgar joke to a couple of associates. The man's previous, equally tasteless public humour over a papal pronouncement brought a lesser outcry and no dismissal. The Pope clearly is not humanity in this view, merely someone with a following. A clerical joke can be bad politics and poor public relations. An ethnic joke is a major sin. It is no wonder that the idea of treason is breaking down. There is no covenant behind the new meaning of treason, and no clear-cut and principled law. High treason and petit treason are now eroding concepts, because the very idea of law is in erosion. Where the rule of law is uncertain, treason becomes a dangerous and vague concept.